Assalamu alaikum, good evening. Welcome again to Legal Ease, where we convert legal jargon into everyday language that everybody can understand to make it easy for the viewers, for those who are not comfortable with the law, with legal terminology. This evening we're going to be talking about retrenchments, because retrenchments we hear every day in the news. It's taking place. Companies are having to dismiss people because they can't afford to keep so many people, because they're changing the way they work because of new technology. And some of you may remember 2 weeks ago we had Advocate Ronnie Bracks, Senior Commissioner with the CCMA. We have him here this evening again, and this evening we're going to be concentrating on retrenchments. But viewers, be aware that when we come back after the break, we will open the lines. The number will be on the screen. And Ronnie said to me just before we went on live that they can call about any labor law matter, any CCMA matter, and he'll be glad to answer that, whether it is fair and unfair dismissal, whether it's employment equity, whether it's fair and unfair dismissal, or of course the main topic for this evening is retrenchment. Ronnie, again, thank you very much for making yourself available, and we're going to be talking about retrenchments.
Yes.
We know that there are only 3 grounds for dismissal,
Yeah.
which is misconduct, incapacity, and retrenchment.
Yes.
And the main topic for this evening is retrenchment. So perhaps for the benefit of viewers who are not comfortable with this, tell us what a retrenchment is, how is it different from other forms of dismissal, and exactly what it entails.
Okay. Thank you very much, Mohammed. And hello to the viewers. Yes, retrenchment is one of those areas that we call no-fault dismissals. Under normal circumstances, they occur because the company had reviewed their financial situation. And often, when they have reviewed the financial situation, it turns out that they're not doing as well as they should. Their profits have dropped, in fact, the law is very clear that there are 3 main areas which could result in retrenchment. The one is the economic area, which of course we're not making as much money as we should be making. And we know now that with the recession and with all those other kind of things that are happening, that companies are not performing as well as they should. And since last year, we know that the number of businesses that have closed or who that is actually downgraded is as a result of economic problems. Right. Then the second one is what we call the structural reason for that. That means that the company has restructured. Certain positions have become redundant. And then, of course, as a result of that, people need to be then laid off as a result of that. And then, of course, we have the one that is always the more problematic one. That's a technological situation that we might find ourselves in. And a good example is that where people, for example, has been putting screws onto wheels and cars on the production line. The company then decides that they can get one of these robots and they can do the work much quicker. They can do it more accurately, especially where there's torque required in terms of those nuts that need to go on. And so under those circumstances, they would use a machine to be able to then conduct the work that would otherwise have been conducted. Now, those are the main reasons why normally there are retrenchments that happen. In fact, those are and remember, when the retrenchment happens, because we call them no-fault dismissals.
Because the employer is not at fault.
It means that there's no fault from any of the parties. Right. And remember, when we deal with the other forms of misconduct and incapacity, it means that in the case of misconduct, that the employee did something which breached the rules of the employer, and as a result of that, action is taken against him. The same thing for incapacity, but it could be medical incapacity, for example. Right. So that the person is not in a position to be able to continue to work because of their medical condition that they find themselves in. And so those are the ones. But in this case, nobody's done anything wrong. And so it is more an outside force that actually is a result of the fact that the company has got to really look at the things. Now our law is very specific with regard to what is the process that needs to be followed. And so if the company becomes aware that, and let's use economic reasons, because that's a much more easier one to deal with.
It's probably the more common as well.
The more common one.
Yeah.
So if the company is no longer producing the kind of, or selling the kind of product that they are used to, and we know, for example, in the iron and steel industries, there's been a big drop in those areas for numerous of reasons, and some of them, the drop of the rand, for example, our rand has become weaker, and so when we are dealing with these kind of things, it means that, of course, that more money is now being spent to be able to get steel and or to actually, that we are not doing as well with the release of the steel into the international markets. So all of those things affect the companies at the end of the day, and that results then, of course, in that people need to be released. Now there are various methods that have been developed with regard to retrenchment. And when the company becomes aware of that, the company has to inform its employees that, look, we're not doing as well as we have been doing in the last couple of months, and so on, last couple of years even. And so under these circumstances, we need to relook at the people that are working. And remember, in most of the companies, the major cost is normally, especially if it's labor intensive, is the workforce.
That's correct.
And so that is where most of the money is then spent. And so when it comes to cutting, that's the first place where it happens. And of course it is normally the lower employees that get retrenched. And that's the interesting part, is that it's not, you would think that companies would go to the higher senior managers and retrench there, because they are the highest earners.
You have to pay them.
Yes, they would rather start at the lower level. And so they are supposed to, immediately when they become aware of the fact that the company is not doing well, they need to inform the workers that there is the likelihood that you would be retrenched, even if it's a slight likelihood, because the law is very specific that when the company becomes aware, they need to communicate that with the employees, especially since it would affect the employees in the long run. And they're supposed to do that by means of a letter, and then that letter should actually be engaging the employees into a meaningful discussion, and in order to see whether or not the dismissals can be either reduced or avoided completely. And so the employees are then given an opportunity to be able to give their input into what they think should be done to be able to, number one, avoid the retrenchments, because that is the main purpose of the discussions that the employer and the employees enter into, is how do we minimize the risk of getting some of the people retrenched? Are there other areas that they can be used? And that becomes an important basis on which the discussions move, is whether or not there are other areas within the organization where we could most probably place some of the people. And so the alternative positions is the first and important thing that the company needs to identify, because they might get rid of some of the positions because they are positions that may not be producing as much for the company, which means that some of the people working in those positions might have to lose their jobs, and in most cases they will lose their jobs. But there could be other positions that they could be placed in that is most probably more productive. And part of that most probably would be, like, for example, closing down the printing department because it's costing us a lot of money, and then absorbing those people most probably in an administrative section because they can play a role with regard to that. Now, all of that is what is normally referred to in law as a meaningful consensus-seeking process. In other words, there is now an attempt by both employer and employees to try and see how do we minimize this. Now, when that discussion happens, the invitation is normally sent out to all those who are going to be affected by the retrenchment.
Right.
And if there's a union in place, the invitation is sent to the union. If there are no unions in place, the invitation is sent out to individuals to invite them to that process. If there are both union and some other people are not unionized, it will be sent to both of those parties to get around the table so that they can see whether or not they can't engage into a discussion. Part of that discussion, of course, will then require that the company would provide as much information with regard to the process to those with whom it's going to enter into these discussions, so that if it's an economical reason, then one would most probably want to look at the balance sheet of the company, right, and the income statements of the company to see where the drops were, and that the drops were not caused really by the company themselves, in that they're spending more money on things that they should not be spending money on, rather than focusing on the employees within the workplace.
So they should look at cutting unnecessary expenditure.
Yes. And part of that cutting of expenditure could also be that they need to do away with, if they're contract workers, for example, that is involved within the organization, that they would look at cutting down on those contractual workers in order to try and see if they can't save money as regard to those aspects. The fault that a lot of companies make is that they often see retrenchment as a way of getting rid of the people that you don't want in the company. All those troublemakers, the people who speak too much, the people that you have a problem with. No, it's unfortunate, but they will get into trouble.
Well, previously it used to be, he's a union member, let's see if we can get rid of him. Yeah.
But that's it. And you see, they are opening up a door for them to find themselves into trouble when it really comes to whether or not the retrenchment was fair, because remember that retrenchment can be challenged if the person believes that they didn't have a fair reason to retrench them, because the courts are focusing on whether or not there is a justifiable reason for the retrenchment. If there's no justifiable reason, then under those circumstances, you can't then say that there was a fair retrenchment that happened. And so when we've gone through those exercises where we find whether or not there are ways in which we can save the costs, and remember, employees just don't have to sit and say, well, we wait this one out to see what happens. They need to participate meaningfully.
Because it's meant to be a consultation process.
And if they've got suggestions, it's going to mean that we can save money. And it has happened often, where employees had come up with suggestions where they were never consulted before to make things work better in the company. And the company has actually come out tops as a result of the fact that they have got now new suggestions from the workers, because the best people to come with suggestions how to save money are those who do the work.
Yeah, because they're hands-on all the time.
And that's the thing. And they could have developed methods, and that's what companies often don't realize, is that the workers develop their own methods of making things work better. Right. And those might be methods that the company has never ever considered in their lifetime. So their inputs become important at the end of the day, because it means that they would be able then to contribute to saving the jobs that needs to be saved. So if those suggestions then put forward, the company then has to consider them, because that is what the whole issue is about, meaningful consensus. And they will then implement them if they are implementable. But of course, let's assume it's a worst case scenario that nothing happens. I mean, nobody can find a solution for the problem. Then under those circumstances, of course, we move then into the next stage, which is the more critical stage as far as the retrenchments are concerned.
Okay, so Ronnie, right now you've concentrated on economic, and it's not about how much profit the company, it's more about whether the company can afford to retain so many employees. We'll continue with this. Viewers, it's time for our break. After the break, we will continue. We will have the number on the screen for you to call in if you want to ask any questions, if you want to contribute towards the discussion, if you want to share any of your experience with us, please feel free to call in. Good evening. We're back on the air. If you've just joined us, we've got Advocate Ronnie Bracks with us, the Senior Commissioner. We're talking about retrenchment. We were busy discussing the reasons why employers can retrench, for example, economic reasons, technological reasons, and restructuring. And Ronnie was telling us about economic reasons. The employer, because of the downturn in the economy, cannot afford so many employees and therefore may be forced to retrench. Ronnie also said to us that as soon as the employer contemplates retrenchment, the employer must start consulting or inform the employees and invite them to consult on ways and means of avoiding retrenchments. We will continue. We will talk about technological reasons, because sometimes change in technology is not about only reducing staff, but it's about different types of skills that are required. Yeah. Viewers, the number is on the screen, 011-086-7777. If you have any questions for Ronnie, if you have any comments to make, if you have any contribution, please feel free to call in. Yeah. Ronnie, we concentrated mainly on economic reasons, but obviously there are technological reasons.
Technological reasons, and it's always a problem where you have low level of people qualified in a particular industry, where there is no specific skill that they require to be able to do the job. When technology gets introduced, that always creates a problem, because it means then that you need people who have a required skill to be able to do the job.
Okay, can I stop you there? We've got a caller on the line. Hello, good evening, Assalamu alaikum.
Wa alaikum salam wa rahmatullahi wa barakatuh.
Please go ahead with your question.
I've been retrenched in January of 2016.
Okay.
Yes.
And they have given us a retrenchment package. The company has given us a package. But my question is, whilst we're in the employ, when we used to work overtime, they used to take a percentage out. For example, if we worked 8 hours, they used to pay us like 7 hours or something. Do I have any report, although I've been unemployed 2 years ago?
Okay, Ronnie, are you clear on the question?
Yes.
Okay.
Yes. Okay. Now, remember, when we are speaking of packages that are paid out, those packages are determined in respect of the salaries that people were earning while they were within the organization. And so the law in section 41 of the Basic Conditions of Employment says that the measure is every completed year work, 1 year salary is what you're entitled to. But we know that there are organizations that normally don't follow the minimum. So it is possible that they could, for example, reach a different agreement with regard to the packages that needs to be paid out. Mm. Now, it doesn't involve issues in respect of what had happened on previous occasions where you have not, most probably have been able to claim those monies, because those monies in any case, if you were going to claim them, you would claim them from the Department of Labor. So the view should actually go to the Department of Labor, and in fact it's now 2 years in any case, so he's going to have a problem with regard to trying to recoup that money by going back to the Department of Labor, because already he's been retrenched for 2 years. And so there's no ways that he could revive this whole thing. If he had done it immediately after he had been retrenched, then maybe he would still have had a better chance to be able to take this matter up. But those kind of issues normally do not get considered when people are being retrenched, because the idea is that when we engage in the consensus-seeking consultations, it is to try and see what is the best way that we can deal, instead of getting people retrenched, to try and keep them within their jobs.
Right.
And so other issues are normally side issues. But one of the things that you will find in a retrenchment package, for example, is the notice period. If there is notice that needs to be given, you will be paid your notice. If there's outstanding leave, you will be paid your outstanding leave. If there is outstanding overtime, you will be paid your overtime.
That has to be paid.
Because that is part of statutory monies. And it seems like in the case of the caller, there has been an underpayment of his salaries. And that is an issue that he needs to raise with the Department of Labour more than anything else. And I assume that the company is still around for him to be able to do so. How the Department of Labour is going to deal with that, I mean, your guess is as good as mine.
And it's money that the employer owes him.
That's right. So, and the fortunate part is that because all these outstanding amounts are now subject to the Prescription Act,
right.
And the law changed in 2015 from a 12-month period now to a 3-year period, he would still be able and entitled to go and claim those fees because they're not falling within the
it's still within the 3-year period.
It's still within the 3-year period. So I would suggest that he goes to the Department of Labour and raise it with the Department of Labour, because there's clearly been underpayment of his salary.
But that's on the assumption that he was earning below the threshold.
That is on the assumption that he was earning below the threshold.
Okay, so viewer, that is, approach the Department of Labour. If not, perhaps you could go to legal aid or one of the sort of private law companies who deal with this. Maybe they will assist on a contingency basis. Some lawyers are prepared to do that, and maybe they could write a letter of demand and claim the money.
Because, I mean, that is one of those kind of things. Also, I mean, depending on what the amount is, I mean, he could just approach the small claims court if he believed that there were amounts outstanding and claim those from the small claims.
Okay, that's an option which we don't often think of.
Yes. And if it's below the 15,000, I think that's I haven't looked at the latest whether that is increased since, but 15,000 is the cutoff. Right. And I've had an experience of somebody had gone, because I also have a program on the radio, took the advice on the radio program and went to the small claims court to claim their salary that has not been paid to them. And in fact, the small claim court assisted them. Okay. So yeah, that's the other option if you believe that that amount was truly underpaid. I mean, and of course one needs to sit down and consult to hear that the money is not most probably been paid in different or on different occasions, because sometimes there's all kinds of schemes that companies have with regard to these kind of things.
Ronnie, a question that often comes up, and I know maybe it's slightly sort of off the track, but during the break we had this question coming in. People want to know about probation.
Yes.
What is probation? How does it work? How long do you put people on probation for? Can you sort of say probation is 3 months, for example, and then at the end of the 3 months extend that probation again? Could you talk about that?
Yes. I think it's always good to start at the purpose. And the main purpose of probation, of course, is to be able to see whether or not a person fits into the culture of the organization. Firstly. Secondly, and just to explain that the culture of the organization, because it often happens that people are employed into a particular organization and they can't fit in with the culture, and you then have incapacity problems. Incompatibility problems really at the end of the day, because it means that the person can't compete with the rest of the people in the way in which the company operates. The second thing, of course, is to understand whether or not the person that you're about to employ will be able to manage the work that is within that organization. And that is the more important part of having the probation period.
For the ability.
Can the person, has he got the capacity, has he got the skills to be able to do the job? Now, probation periods vary, and they vary from anything from 3 months up to a year. And some of the governmental organization even have the year period of probation, which is normally in other industries very unusual, because you will not have such a long period where a person needs to work under probation. And as I said, that it is there to be able to determine the skills. That means that there is a monitoring process that happens throughout the probation period of the person, so that there is a report back to the person whether or not, as far as the work is concerned, whether they are managing the work, and if they are not, that we counsel them, and we call it counseling, so that we sit around the table and say, but it seems like you can't cope with this. Let's focus on this and see how you can do it better. Do I need to get a mentor for you?
We'll come back to that, Ronnie. We've got a caller on the line. Assalamu alaikum. Good evening. Your question?
Assalamu alaikum.
Wa alaikum salam.
My question is, how many hours a week you are allowed to work?
How many hours a week?
Are you allowed to work?
Oh, okay.
Are you allowed to work?
Yeah.
Yes, my name is Ayub Kezi, yeah?
All right. It is 45 hours per week, depending on the industry that you work in. Some industries work 40 hours per week, and you can find that out, of course, if there are bargaining councils that are available. The bargaining council will be able to tell you exactly what the hours is. But in terms of the basic condition of employment, it is 45 hours. Any hours out over that, it will be overtime, and that would be worked on an agreed basis between the parties, unless, of course, you are in the security industry, and there's a special dispensation of 12 hours that they work per day.
Okay, but still to a maximum of 45 hours a week. Okay, yeah. So it's 45 hours a week, and if I remember correctly, the basic conditions of employment act says not more than 9 hours or not more than 8 hours, depending on 5 or 6 days.
Or whether 5 or 6 days that you work
okay.
at.
So it's 45 hours. If you, for example, in the metal industry, then it will be 40
hours. Yes.
As Ronnie said, you need to check if there's a bargaining council, because bargaining councils make their rules, and sometimes it is better conditions than what the law requires, because the law would specify minimum conditions, which you shouldn't exceed, but of course by agreement that could be reduced.
Yes.
Okay, so we've discussed the probation. We were busy discussing technology.
Oh yeah, we were still talking about the probation. Now the second stage of the probation, of course, is that the person needs to be informed all the time of their progress. When they reach the 3-month period, if it's 3 months or whatever the period is, the law allows for an extension in the event that you believe that the person most probably needs furthermore time to be able to meet the requirements of the company. And normally before that happens, the person who's on probation employee needs to be informed that, look, we intend extending your probation because we believe that you have the potential to be able to meet the standards that we require. But under the circumstances, we think that the time might be too short for you to be able to meet that standards within. And then, of course, by agreement, it will be then extended to a particular period. If the employee does not meet the standards, it means that at the probation period, they're entitled to say to the employee that, look, it seems like you've not been able to meet the standard. We've done the counseling that we needed to do. And normally that would be done at a hearing where you would tell the employee that, look, you have not met the standard, and under circumstances, we're not going to appoint you on a more permanent basis within the organization.
Okay, so clearly it's time for a break, but just before the break, just so clearly you can't leave the person there for 3 months, not say anything. At the end of the 3 months, say, sorry, your probation period is over, you haven't performed, you're dismissed. There must be monitoring, during the 3 years. Viewers, time for a break again. At the end of the break, we will continue talking about retrenchments, but if you have any questions, please feel free to call in. We will take that break. Please stay with us. Welcome, Assalamu alaikum, welcome back. Our guest this evening, Advocate Ronnie Bracks. We're speaking about retrenchments, but we're also speaking about other aspects of the law. We were speaking about probation, and during the break again, this so often happens during the break, we get these questions coming in because people can't wait till after the break to phone in again. So therefore, and the question that came in is, what happens, Ronnie, in the case of a change of management or company is sold to another company, or there's a merger, or buying out? Do employees lose any of their benefits? Where do the employees fit into this?
Our law makes provision for where there are takeovers, and what we normally say is the takeover of the company is a going concern. In other words, the only thing that happens is that you've got a new person that is working in the place where management used to be.
Right.
But the rest of the company still remains the same. Under those circumstances, employees' rights are secured within that organization. In fact, the law actually gives great protection to employees, because if the terms and conditions are changed of those employees under those circumstances, they are entitled to be able to refer their matters to the CCMA as a constructive dismissal,
right,
because it means that they are no longer working with the same terms and conditions. And normally when it's taken over like that, they don't lose their service record, because that becomes important. And a lot of employees do not understand it, and what they normally say is that, well, I want to be retrenched from the old company so that when I get into the new company, I will have the benefit of all the years that I worked for the old company.
Right.
But in fact, you are better protected under those circumstances, because all those years are taken over by this new company. And if your old company was on the verge of going down, in any case, I mean, we would lose more as a result of that. But now you are taken over by a new company. So the rights of employees are protected under those circumstances, because they continue as it's business as usual, to put it that way, except that it's now business as usual under new regime.
Right.
And they can then work with the employees, and if there are terms or conditions that they want to change, they need to enter into negotiations with them, as long as none of those drop to the level where they are less than what they had been, or worse than what they were when they were working for the old organization.
And I suppose the way to think of it, an employee needs to think that it's not the person who's the employee. Yes. It's not that manager who's the employee. The company is the employer. So even if that company is taken over by new managers, yes, company remains the employer. They don't lose their long service. They don't lose their conditions. Yes. And if the company is sold to another company, the new employer then takes over all the obligations,
of the old employer. And the law even goes further to say that there are circumstances where both the old and the new employer can be held jointly liable if there were certain claims against them. So you're always protected under those circumstances.
Okay, we had a call. Is the caller gone? The call is gone. Sorry, we had a caller, and that call was dropped, unfortunately. Ronnie, we spoke about probation. We spoke about economic reasons. We spoke about technological reasons. Technological reasons, sometimes it's not. Hello?
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 We thought we'd lost you. Okay, your question?
Hello, assalamualaikum.
Wa alaikum salam.
Hi, Mohammed.
Alhamdulillah.
Mohammed, assalamualaikum.
Wa alaikum salam wa
Hi,
rahmatullahi.
Mohammed.
Alhamdulillah, I can hear you. Go ahead with your question.
MashaAllah. Mohammed, I would like to ask you one question here, Mohammed.
Right, go ahead.
My question is, how does the retirement fund work, Mohammed?
Could you do us a favor? Could you mute your TV and then ask the question, because there's an echo coming through. We can't hear the question. Hello, have we lost that caller? Hello?
Hi there.
Hello?
Go ahead.
Hi, I'm still here.
Oh,
Yes.
okay. Let's hear the question.
I'm calling from the Cape area.
All right.
Just good evening to you.
Good evening.
I'd like to find out. I was calling to the office and just said that, look, you've been retrenched.
Yes.
Is that the proper way to do things?
No.
Clearly not.
Clearly not.
Okay. Ronnie will explain to you the procedure, the consultation. What is required is a proper procedure,
yes,
and a valid reason for the retrenchment. And Ronnie will talk to that.
Yeah.
All right. So what he said was that the employer
Yeah.
said that the company's not doing well.
Yes.
And I was the only one that looked at having this distinction.
Okay.
So you were the only one that was selected for retrenchment.
That's correct.
Okay.
What, now how many other employees are within your organization?
There's about 7 in total.
Did they tell you why were you the selected one? Is there an area that you work in that have become redundant or
Not at all. All that he said was the company's not doing well.
And your position in the company, is it the junior position? Is it the senior position?
Senior position.
It's a senior position. And how many other seniors are there?
Only myself. I'm the most senior.
Okay.
And then we've got middle management and then
Yes.
junior staff.
Okay. So you are the highest paid, I assume, from the people that are there.
That's correct.
Okay. Right. Thank you very much.
Ronnie will answer
All
your
right.
question. Please.
Okay, and it works. So just in terms of the procedure,
Yes.
do I go to the CCMA? Do I hand the labor lawyer?
I will talk to you about that as well.
We'll
Okay,
discuss
and
the
then
procedure
one more
required.
Also, one more thing with regards to the UIF as well.
Okay.
How does one go about, or can I go ahead, or do I have to wait for the CCMA case?
Okay, we'll talk to that. We'll talk about the procedure required for
Yeah.
the retrenchment. We'll talk about what is the substantive requirements for
Yeah.
the retrenchment. We'll talk about the dispute procedure. In other words, what
Yeah.
you can do now that you've been unfairly dismissed, and clearly you've been unfairly dismissed.
Yeah.
And Ronnie will also talk about the UIF that you can claim.
Yeah.
You don't have to wait for the CCMA case. You can go immediately and claim as soon as you have your retrenchment letter.
Yeah.
But Ronnie, over to you.
Let's go. What normally happens is that if you are going to be retrenched, one of the things that needs to happen is that a notice must be given to you as the effective employee by the retrenchment. So the company tells you that we are in the process of doing that. The notice must be in writing and must contain the necessary information for you to be able to make a representation to the process that I refer to as the meaningful consultation process. And some of the information that must be included in that notice is that there must be a reason for the proposed retrenchment, the options that was considered by the employer to avoid the necessary retrenchment, and of course, the opportunity for you to make your own presentations to the employer, and if they are rejecting your proposals, the reason why they are rejecting your proposals. The third thing that needs to happen is that you must be told what is the selection criteria. Why were you selected as the person that needed to be retrenched? And of course, then there is the time when the retrenchment is likely to happen. So there need to be sufficient time given. Normally, part of that period that is given is that it also allows, in the event that people need to go out and look for alternative employment, that the company gives time for people to be able to go out and get the alternative employment. The way that the caller described it is of course unprocedural, because the company had failed to follow the process as we had laid out in the beginning about when they became aware that there's a likelihood of retrenching, that there needs to be a warning given that, look, this is what's going to happen under those circumstances. The next thing that then happens, that if they had followed the correct procedure, if they still come to the conclusion that the suggestions that you had made as to an alternative to retrenchment is not going to be workable, they then must give you the necessary notice that you're going to be retrenched. They must then tell you the day on which you're going to be retrenched. They must give you the notice pay that goes with that kind of retrenchment, as well as all other outstanding monies that needs to happen. If you are unhappy with the way and you believe that the company has not followed this procedure, your remedy is to go to the CCMA and refer an unfair retrenchment. Remember, we said at the beginning that retrenchments are dismissals. They are no-fault dismissals, which means that under those circumstances, technically speaking, you have been dismissed from your company, and in terms of the UIF, you are entitled then for that dismissal to be able to go to the Department of Labour and lay your claim. You don't have to wait for the CCMA procedure to be concluded, because you have a limited period for your matters to go to the Department of Labour. You've got 6 months within which to lodge your issue with the Department of Labour, and you could find yourself into trouble if you try and first see the CCMA process through, because it might take you much longer than the 6 months, and then you will be out of time for you to be able to lodge your claim.
Okay, so the viewer needs to go to the CCMA within 30 days.
Within 30 days.
Within 30 days from the date of dismissal, apply to the CCMA on the 711 form. It's called 711 because that's the marking on the form. You apply on there. It's easy to follow through. You mark that you've been retrenched, or it may say dismissal for operational requirements. Mark that it's procedurally unfair, substantively unfair. It'll also ask you what's the remedy you require on that form. You could say, you could leave it blank, or you could say compensation or reinstatement, but you need to do that within 30 days from the date of the dismissal.
And that, of course, is that if he wants to go back to the company.
If you want to be reinstated, you can be reinstatement, or if you want compensation, the arbitrator can award up to a maximum of 12 months compensation. And with that, we'll continue after the break. Time for the break, viewers. We'll take a break. Please stay with us. And after the break, the number will be on the screen again. Please call in if you have any questions. Welcome back. We've got Advocate Ronnie Brack, Senior Commissioner. We're talking about retrenchments. Just before we took a break, we had a call on there who spoke about how he was retrenched. The company just called him in and said, you are retrenched. And clearly that was unfair because they didn't follow the procedure. They didn't consult adequately. They didn't give him, we assume he's been working there for more than a year because he was a senior person. They didn't give him the 4 weeks notice. So therefore, clearly it's an unfair retrenchment, should go to the CCMA. We've got another call on the line. Assalamu alaikum, good evening.
Good evening, how are you?
Blessed, thanks. How are you?
Okay. Sir, I was a councillor for 10 years.
All right.
Yes.
And then I was re-elected, and then I was taken out. So I don't really know how to go about it. The advocate should help me. Thank you.
Okay. So, sorry, are you still on the line?
Hello? He's gone.
I wasn't quite sure of the question.
He says he was a councillor for 10 years.
Yes.
And that he was taken out. Maybe we can help him.
Yeah,
no, I mean, I don't know whether councillors are employees or not. I mean, because the thing is that
he was reinstated and taken out.
Well, it seems like, you know, because the councillors get elected normally to the position. So, I mean, they would not fall under the normal Labour Relations Act under those circumstances, because they
unless he was a councillor in a company where he was working and he was dismissed and reinstatement.
Well, I understood him to have been one of the political councillors.
Okay, and that's an elected position.
And that's an elected position. Yeah. And then he was taken off, he said. He doesn't know why. And I mean, that is a party issue. So, you know, when parties decide no longer to use councillors, I mean, they have the right to be able to do it.
Okay, if you're watching, please call in, because we need more information. We need to determine whether you're an employee, whether you are an independent contractor, whether it's a political appointment, you know, at the call of the company, or whether it is an elected position. We need that information from you. Okay, but Ronnie, perhaps let's speak about, because the person who called in is the only person that was retrenched. So he goes through the conciliation process first at the CCMA, and therefore arbitration he can choose.
He can choose.
But before you continue, we've got another caller on the line. Assalamu alaikum, good evening.
Hello, good evening.
Good evening.
Assalamu alaikum.
Wa alaikum salam.
My name is Saeed.
Saeed, go ahead with your question, please.
Okay. I was working for company A. We are outsourced to do maintenance for company B.
All right.
Company B couldn't pay company A where I was working. So our company decided to cancel a contract, and they were not to retrench us, but they said it's a 197 agreement. But the workers said they would rather prefer to retrench than going to other company B. So the two companies negotiated our future. The salaries were less than what we were earning in Company A. But Company A said, listen, it's not a 197. You are applying for a new job. But the company we worked for said, you can negotiate settlement to 197. So we are not retrenched. We signed new job offers, different salaries, in fact lower than what we earned before. And that's where it ended. So should we be having retrenched, or should we just accept that it's not a 197 and carry on?
No, but you see, if it was a 917, then of course your work would have just continued in the normal course of events. But here you are entering into a new contract.
Yes.
And if the company that, and it's with a new company, so you would have expected the company that you were coming from to enter into a retrenchment process with you. Because when you start this new job, your service record is not going to continue. Unless, of course, in the contract there's a clause that says that your service record continues with the new company. That means that you would have lost all the years that you've worked and you would not have been compensated for it. So I would have thought that your first company would have retrenched you before you enter into the agreement with this new company, because you say quite clearly it's not a 197 takeover. Under those circumstances, you've got to go through the two different stages where you retrench from the one company and then you enter into a new agreement with the new company.
You see, my previous company said they believed it was a 197. But the other company said they can't take on as a 197. We must reapply for the jobs.
Yeah, but you see, it is quite clear that if you are asked to apply for the jobs, it can't be a 197, because a 197 normally, and just for the listeners' advantage, is that's a takeover as a going concern by one company of another company, and they made it quite clear that it can't be a 197. So your company should not be confused about it, because contracts would have been entered into by which the one company sells to the other company as a going concern. And if those contracts are not in existence, that means that you should actually bring a issue against your old company for an unfair retrenchment, because they should have retrenched you. In fact, I would bring for unfair dismissal and let them raise the issue about that they have retrenched you.
Thank you very much.
All right.
I think the unions are having a legal court case in May next year, so until that extent.
Okay.
Okay.
Good. God bless.
Appreciate it.
Right up. Bye-bye.
And we will have Ronnie Braxton again in 2 weeks' time. So if you still have any questions, you can call in. I think that previous caller that we lost is back, the councillor.
Hello.
Hello. Go ahead with your question.
Yes, my question was put to the advocate.
Could you please put your TV off at the back? It's interfering.
Yeah. Okay,
there's an echo.
Okay.
Yes.
Okay.
Your question is?
My question was put to the advocate.
Yes.
He sent me to call back. Yeah. So I called back.
Yeah.
We need clarity on your question.
You said you were a councillor.
I was a councillor, a ward councillor, a PR councillor.
A ward councillor.
And a PR councillor.
So you were
on the 16th of on the 3rd of August 2016. I was re-elected as a PR councillor. But for whatever reason, my party took me out.
Okay.
So I have got no clue.
All right.
What is the reason? They haven't given me any reason. They said with immediate effect, I must resign.
Did you go and find out?
Due to the KZN problems of shooting and all those things, I was scared and I had to sign the document.
All right. Did you find out from them why they decided?
Okay, but so,
no, they won't give me no answers.
Sorry to do this. We have to stop you there. It is a political. We've got a half a minute in which Ronnie has to answer this question, but he will be back in 2 weeks' time. You can call in again if your question hasn't been fully answered, or you can call in next week when Ashraf is on the line. You could ask that question to him as well.
But just to answer the question is that it doesn't seem that the caller falls under the Labour Relations Act. It's clearly a appointment as a councillor that is regulated by the Municipal Act and many other kind of things. And so under those circumstances, we won't be able to assist him.
Okay, because it's not an employer-employee relationship, so therefore that doesn't fall under the Labour Relations Act or the Basic Conditions of Employment Act. Okay, viewers, Ronnie, again, thank you very much, and hope to see you in 2 weeks' time when we will continue with retrenchments and perhaps other topics as well. So, viewers, in 2 weeks' time we will be back, but next week as well, Legal Ease next week, Monday, with Ashraf Isup on the line. I'm not sure what his topic is for next week. But he will be here, and if you have any questions for him, you could ask him questions or for his guest as well. So we have been talking about retrenchments, about fair and unfair retrenchments. We spoke about probation. We will continue with this because clearly a lot of the questions have been unanswered, and we'll be back with the topic in 2 weeks' time.
Good night.
Assalamu alaikum wa rahmatullah.